This is a lunchtime seminar of the Business and Human Rights Access to Justice Lab. We're delighted to have Professor Sara Seck with us today. Just before I introduce Sara properly, a couple of formalities. So firstly, we are recording this meeting. We're recording it and it will be put up online in a few days' time, so just to let everyone know that. Sound is hopefully all okay now, so that's all done. I'll also take this opportunity to acknowledge the traditional custodians of the land on which we are meeting, the Wallamatical clan of the Darug Nation, and to pay my respects to elders past, present, and emerging. And now I will welcome Professor Sara Seck. Sara is a professor at the Schulich School of Law and director of the Marine and Environmental Law Institute at Dalhousie University in Canada. And Sara is here to speak to us today on the topic of the ocean climate nexus, human rights implications of the climate change advisory opinions for fossil fuel businesses. So this is talking about three international court advisory opinions that have come out in the last year or so, and the implications of that for business and human rights and that kind of space. So Sara will be talking for around half an hour, and then we'll have around half an hour for questions from the room and also online. People online, if you do have a question, feel free to type it into the chat anytime you like, and we can go through those after Sara has finished. And there'll also be an opportunity for you to raise your hand and ask a question that way as well in the second half of the session. Okay, I think that's all I need to say. So without further ado, Sara, please.
Thank you very much for that introduction and also for the invitation to be here today. I very much appreciate the opportunity to share what are essentially some preliminary thoughts as I'm reflecting on the climate advisory opinions, particularly through a lens that I call the ocean climate nexus. And one reason for doing this is frustration in the Canadian context with the way in which very heavily dependent fossil fuel provinces like Alberta, which is host to the oil sands, and Saskatchewan, continue to challenge federal jurisdiction and the exercise of jurisdiction under our Federal Impact Assessment Act. And they do so in part by saying that fossil fuel developments that are taking place in the provinces in Alberta are really subject just to provincial jurisdiction. But the federal government actually has jurisdiction over fisheries, for example, and pollution of oceans, marine dumping. So what we learn from one of the climate advisory opinions, the International Tribunal on the Law of the Sea, is this idea that greenhouse gas emissions are pollution of the marine environment. And if that's true, then that seems to me something that might be important within the Canadian context for analysis of federalism doctrines, which could have implications for how we regulate and how we understand the possibility of regulating fossil fuel enterprises. So for me personally, that's sort of where the motivation comes from. But my sense is that more generally, the ocean is missing from climate thinking, and the ITLOS advisory opinion shows us how to really shine a spotlight on ocean climate. And so from a business and human rights perspective, we might want to think about what tools that might enable us to use that we wouldn't necessarily have thought of before. So that's sort of loosely where I'm coming from, and as you'll see, this is very much unfinished work, but I think it's important work. And of course, the click is not working right now, but let's try it again. There we go. Okay. All right. So first off is just to reflect on the climate advisory opinions themselves. As David has said, there are 3 of them that have been released so far. The African court is going to be also releasing one. There are, of course, other cases, contentious cases, for example, in the European Court of Human Rights. But looking at these three, I'm going to focus on the ITLOS decision, which is the first one. But as we'll note, it doesn't actually explicitly engage with human rights. Therefore, it's important to think about what the advisory opinion at the Inter-American Court of Human Rights has to say, as well as the International Court of Justice's advisory opinion, both of which refer to human rights, and in some cases refer to business responsibilities as well as state duties, and also talk about fossil fuel enterprises. One of the really critical things I think that comes out of the climate advisory opinions, though, is in a sense the decentering of the climate regime from climate conversations. So sometimes there can be what some people refer to as sort of a climate tunnel vision, where we think everything is going to and needs to happen through the UNFCCC and the Paris Agreement, and there's nothing else really going on in the climate space. And what comes very clearly through all these decisions is that we need to be looking beyond the climate regime, and that includes obviously the UN Convention on the Law of the Sea, so this is equally relevant to thinking about climate, as well as international human rights law. These decisions, of course, all came through different processes, through different initiatives. They are subject to different, they're sort of, because they come through different institutions, they have different rules in terms of the kind of law they can consider and how they consider it, and therefore there are a lot of different implications of these. But certainly we're seeing lots of people considering all three, and so I don't think it's you know, it's not a strange thing to be doing that here. So why the ocean climate nexus? So I am at Dalhousie University, and we have a lot of ocean scientists at Dal. We get a lot of funding from the federal government, much of which these days is coming through something called the Ocean Frontier Institute, and most recently it's Transforming Climate Action Initiative. And ocean scientists are very worried about the ocean and are very worried about the ocean climate challenge. As somebody who initially, started my career looking at, home state obligations in relation to Canadian-based mining companies operating internationally for human rights, environmental issues, and sort of I focused on that when I was at Western Law for 10 years. Then I come to Dalhousie, and all of a sudden everybody wants to talk about ocean. So it's been a while for me to sort of try to wrap my head around what does this mean? What are the similar lessons? What are the different lessons? But the key point is that we need to talk more about the ocean climate nexus if we're actually going to really address the climate challenge. And so the ITLOS advisory opinion starts, as they all do, by talking about what does climate science say. So what does the IPCC have to say about this issue, and in particular, what does it say about the ocean? So we have a lot of different things. First, the climate regime itself talks about the importance of reducing emissions, but also the importance of carbon sinks. And the ocean is a huge carbon sink. So the ITLOS decision in describing the climate science says the ocean is a fundamental climate regulator on seasonal to millennial timescales. And this is for two reasons. First, that it stores heat trapped in the atmosphere by increased greenhouse gas concentrations. So the ocean stores 90% of the heat. And secondly, because it stores about a quarter of the excess CO2. The result of this is that climate change has caused substantial damages and increasingly irreversible losses. And this includes to coastal, but also open ocean ecosystems. And so as business and human rights people, when we think of open ocean ecosystems, we don't intuitively think of human rights. This is where I think we need to shift understanding. And so when they talk about the effects, this includes obviously sea level rise, which everybody hears about because that's got a lot of traction. But less so have we heard about the increasing ocean heat content and its implications for the heat waves, the issue of ocean deoxygenation, and also ocean acidification. So these are all different things, but combined, they have grave implications for marine organisms. For if we think about ocean acidification, for example, the ocean becoming more acidic is corrosive for marine organisms. There are issues arising with deep ocean biodiversity impacts, which are resulting in large-scale changes to food web structures occurring in all oceans. There are mass mortality events linked to this. So again, this seems ocean environment, marine environment. It doesn't intuitively seem human rights. The ITLOS advisory opinion does make reference to the idea that there are, again, drawing on the climate science, that there are human communities, especially those linked to coastal environments, who are very dependent on the ocean. And so this obviously impacts fisheries, and it has cultural impacts and so on. So that's in there. But is it enough? Whoops. Now, as I noted, ITLOS does not address in any detailed way human rights. In fact, the decision, which was unanimous, simply says that the tribunal notes that climate change represents an existential threat and raises human rights concerns. And then they don't say anything about international human rights law. So you'd think this is a missed opportunity. There are separate declarations, and one by Judge Sara quite clearly says that ITLOS has made a mistake, sidesteps the need to construe Article 293 on applicable law as covering human rights issues, but then says that nevertheless, in arriving at the conclusion on the nature of the obligations, the tribunal has duly borne in mind and been motivated by the human rights concerns. So my claim would be what the tribunal actually says in reading this declaration creates an opening for us to say, okay, how can we read the ITLOS decision through a human rights lens? And then what might that mean for business and human rights? Now, to do that fulsomely, though, we might need to turn to what some of the other advisory opinions have to say and some other developments. So first of all, we know in 2022, the UN General Assembly recognized the right to a clean, healthy, and sustainable environment as a human right. No states voted against this UN General Assembly resolution. Canada voted in favor while saying, well, we don't really know what it means, and we look forward to learning from the international community as to what it does mean. So hopefully, we see in the International Court of Justice climate advisory opinion some explicit engagement with the right to a clean, healthy, and sustainable environment. And in fact, after the first set of submissions, there were some questions that were presented to everybody to provide responses to, and one of them was to tell us a little bit more about this right to a clean, healthy, and sustainable environment. And then in the decision, we see a clear statement in this first paragraph that this right needs to be understood as a precondition for the enjoyment of many human rights, that in fact, under international law, it is essential for the enjoyment of other human rights, and that it's difficult to see how human rights obligations that states have can be fulfilled without at the same time ensuring the protection of a right to a clean, healthy, and sustainable environment as a human right. So we have clear endorsement of the existence of this right, but if we actually take a look at the decision as a whole, they don't really do a whole lot with it. And so that, one could say, is also a gap. So there's more that could be done, but at least we have clear recognition of the ICJ. This is a right that exists. Other human rights are dependent on the realization of this right. That's super important. Doesn't quite take us all the way, I think, though, it doesn't take us quite as far as what we see from the Inter-American Court of Human Rights. And this decision talks about a ton of stuff, which I'm not going to talk about, but the one piece that I think is really helpful for thinking about the ocean aspect is the framing of the human right to a healthy environment as a fundamental right for the existence of humanity, with a collective dimension, which constitutes a universal value owed to both present and future generations, but also having an individual dimension, and really importantly, the view that it is an autonomous right that protects the components of the environment, such as seas, as legal rights in themselves, even in the absence of certainty or evidence of risk to the individual. So this means it protects nature not only because of the effects it may have on other human rights, but because of its vital interdependence with other living organisms that makes life on this planet possible. So we can take that, reflect back on what ITLOS and climate science tells us about the central importance of ocean, marine biodiversity, marine ecosystems, climate impacts on all of those, and say there is a human rights dimension to these ocean harms, even if it's challenging to figure out exactly who is the human who might go to court to say, my rights have been violated in this context. Now, at the same time, it's interesting to note that through the Human Rights Council, and perhaps especially the work of the Special Rapporteur on Human Rights and Environment, there's been a report on the ocean and human rights that talks about the marine environment, human rights and marine environment. And there was also a resolution on the ocean and human rights in 2025. So you can look also the ideas coming through the Human Rights Council to sort of expand upon, okay, how are we to think about human rights in ocean? What does this mean? And so I think this all sort of comes together. Oops, okay. What about fossil fuels? ITLOS doesn't say anything about fossil fuels. On the other hand, the ICJ does. This again was one of those issues that the court went back and said, look, we have these questions. Can you give us a little bit more information about what you think? Do fossil fuel dependent states have greater obligations? What might those be? And so we see here in the consideration of question 2 in the ICJ Climate Advisory Opinion, the statement that failure of a state to take appropriate action to protect the climate system from greenhouse gas emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies, may constitute an internationally wrongful act which is attributable to that state. Now, many people have talked about this paragraph sentence many, many times. Well, what does this mean for thinking about the marine environment? So the first thing is, what does it mean for a state to fail to take appropriate action? And the court here emphasizes it's not the emissions of the greenhouse gases per se, but it's the breach of conventional and customary obligations identified under the first question. Now, what's identified under the first question aligns in many ways with what ITLOS finds, although it's also different, and I'm not going to get into sort of all the details. But I think the key point is, what would it mean to fail to protect and preserve the marine environment as required by the UN Convention on the Law of the Sea? And if a state fails to do that and continues to support fossil fuel production, consumption, exploration licenses, and so on, is it therefore engaged in an internationally wrongful act? So this, I think, is where we need to go. Now, I have 4 fairly detailed slides, which I'm not going to go through in detail, but they're here for people to sort of reflect on. So the ITLOS Advisory Opinion itself asks 2 key questions. What are the obligations of state parties to the UN Convention on the Law of the Sea? First of all, to prevent, reduce, and control pollution of the marine environment in relation to the deleterious effects that result or are likely to result from climate change. And then note how they phrase this, including through ocean warming and sea level rise and ocean acidification. So climate change, ocean acidification are not the same thing, and which are caused by anthropogenic greenhouse gas emissions into the atmosphere. Now, this question is generally answered with reference to Article 194, as we shall see. The second question is, what are the obligations to protect and preserve the marine environment in relation to climate change impacts, including ocean warming, sea level rise, and ocean acidification? This is understood as more closely relating to Article 192. And the court suggests, as many submitters did, that Article 192 is actually broader. And so 194 is sort of part of 192. but they nevertheless start with 194 and talk about that in fairly great detail. Now, as with all the other advisory opinions, the question here is very specifically focused on UN Convention on the Law of the Sea, yet nevertheless it's understood that applicable law is not just the UN Convention on the Law of the Sea. You need to read state obligations harmoniously. And so what we see in Article 293 of UNCLOS is that the applicable law would be UNCLOS and other rules of international law that are not incompatible with it. Now, the tribunal seems to take the position that nothing is incompatible with it, and the critical approach might say, I don't really know if that's true, but we can leave that aside, just think about it as we sort of move on. So to answer the first question, the first thing that has to be established is that there has been pollution of the marine environment. And so the tribunal looks at the definitional provisions in Article 1 and says, yes, indeed, anthropogenic greenhouse gas emissions are pollution of the marine environment. And this is, again, that there are two different ways that this happens. They suggest that as substances, they can be understood as being introduced directly by humans into the marine environment. And as heat, they're introduced indirectly by introducing energy into the marine environment through emissions. Now, I'm not a scientist. I don't totally understand these nuances, but I actually think these nuances are important. And this relates to, as one develops arguments over things like jurisdiction or federalism in the Canadian context, it might be important to really understand this and to be able to explain it to a court, to be able, for them to be able to understand what's going on. Clearly, there are deleterious effects, actual effects, and also potential effects. The other part then is, what does it mean? So we're going to this first question. What are the obligations to prevent, reduce, and control pollution of the marine environment? This is clearly taken from Article 194. States have to take all necessary measures to reduce and control pollution of the marine environment from any source with the aim to prevent its occurrence altogether. So the tribunal says immediate cessation is not required. We could contemplate that. That's clearly the opinion that the climate regime has taken, and there are a lot of critical pragmatic reasons why immediate cessation wouldn't make sense. I wouldn't be here for one thing if there was immediate cessation, but then again, we have Zoom, so maybe, you know, maybe that would be okay. But so we can think about whether that's compatible or not, but that is what the provision says. So what does it mean to take all necessary steps? Well, there's lots of stuff. First, compliance with the climate regime with Paris is not enough. That's a floor, it's not a ceiling. UNCLOS itself has more, and a failure to comply with UNCLOS engages state responsibility. So then it talks about all the different stuff. Mitigation, that you have to use an objective lens, it has to be based on science, you have to look to international rules and standards, you need to use all available means, it might depend on your capabilities. It's an obligation of stringent due diligence of conduct, not result. And it's stringent because the harm to the marine environment is so severe. So what do you need to do? Legislation, administrative procedures, enforcement, exercise adequate vigilance to make sure the system operates effectively. And there's also reference to Article 194, paragraph 2, which talks about transboundary pollution and activities under state jurisdiction or control, and talks about the importance of the need for states to ensure that this pollution does not spread to areas over which it doesn't exercise sovereign rights. So there's, again, conceptual work that could be done here to try to think about how to frame what it is in different contexts. A precautionary approach must also be applied in the context of due diligence obligations. And so there's a lot in this 194, and that's just a bit of an overview. Importantly, though, there's also Article 195. And we do not see this talked about, as far as I can tell, in any of the other advisory opinions. So here, Article 195 says that when taking measures to prevent, reduce, and control pollution, it must not transfer directly or indirectly damage or hazards from one area to another, or transfer one type of pollution to another. What does this mean for carbon credits, carbon offsets, the development of marine geoengineering, marine carbon dioxide removal? Isn't the entire sort of market mechanism approach, or the carbon trading approach, kind of counter to what this has to say? The tribunal doesn't say, it sort of, waffles around it a little bit, again, because the climate regime clearly not only allows, but encourages and enables those responses. But does that really fully align with the UN Convention on the Law of the Sea? Two more deep ITLOS slides, but I'll try not to do too much deep. Still on this first question, there's a lot more that is said. First is, we might think pollution of the marine environment is just something that kind of happens at sea. But ITLOS very clearly says, look, this can happen through many different sources of pollution. And one, under Article 207, clearly identifies land-based sources as one of the possibilities. So again, I'm thinking back to, Alberta and fossil fuel development in a province that is, not next to the sea, right? Article 207, it's a land-based source. This is covered. It also talks about, of course, vessels and lots of other stuff, but for my purposes, the land-based piece is important. There is an obligation of enforcement that attaches. So there needs to be monitoring, inspection, investigation, prosecution, the availability of judicial or quasi-judicial proceedings. And in Article 234, an obligation to ensure that recourse is available in accordance with the state's legal systems for prompt and adequate compensation or other relief in respect of damage caused by pollution of the marine environment. So what would that mean if we think of greenhouse gas emissions as harming the ocean, for example? Who is going to go to seek this compensation? How could someone, a state? What does this mean? What could this mean? Lots more that could be said. Other provisions talk about monitoring, reporting, and assessment. So we know from the ICJ and more generally that customary international law provides that there is an obligation to conduct environmental impact assessments of planned activities, whether they're by private actors or by states. And we see that also in the marine environment context. And the tribunal talks about this, talks about the importance of accounting for cumulative effects, sees this again as part of a due diligence obligation, and also makes note of the fact that under the new B&HR treaty, there's lots more that's said about environmental assessment there, and maybe that is also relevant. We shall see. And so my final ITLOS slide takes us to question 2, which is this obligation to protect and preserve the marine environment. So again, this is a broader obligation. Article 192 is said then to create a positive obligation to take measures to protect and preserve the marine environment, a negative obligation not to degrade it. Preservation may include restoring marine habitats and ecosystems that have been degraded. If we think about carbon sinks and blue carbon ecosystems, we can think about how to link mitigation and adaptation and resilience. It's again a stringent due diligence obligation that requires states to ensure non-state actors under their jurisdiction or control comply with these measures. And then going back to Article 194, paragraph 5, this is spoken of here, is an obligation in relation to rare or fragile ecosystems and depleted habitat. So again, there's lots more in here, but even in that, we see the conversation that needs to happen. So on the one hand, we have the ICJ saying that a failure of a state to take appropriate action to protect the climate system from greenhouse gas emissions, including all this stuff relating to fossil fuels, may constitute an internationally wrongful act. ITLOS talks about what appropriate action is under the UN Convention on the Law of the Sea, what these obligations are, to exercise stringent due diligence to prevent, reduce, and control pollution, including from land-based sources, to protect and preserve the marine environment, to regulate private actors, impact assessment, all kinds of stuff, including recourse and restoration. So I think this, to me, is interesting. And this then leads to, from a business and human rights perspective, once we sort of have done with, states have obligations to do all of this stuff, but they're not really connecting the dots and doing this. Is there a way to use these materials and these ideas to frame or reframe business responsibilities, to frame or reframe the responsibilities of fossil fuel enterprises so that the ocean is actually made visible? Harm to the marine environment is a climate issue. And so what does this mean? And I think I have one more slide, which is simply just to say, I think this is an important conversation. I think there are implications for legal strategies. Certainly in the Canadian context, I'm planning to look at these federalism questions and say, hang on, we have to bring the ocean into federalism analysis. We have to bring the ocean into climate litigation strategies. But there's also clearly further research required to figure out these different pieces. So that's as far as I've gotten, and I look forward to comments, questions, and staying in touch with anybody who's interested in this topic.
Thank you so much, Sarah. Yeah, I mean, absolutely amazing presentation. Thank you so much. And there's so much going on in this space, isn't there? I mean, it's massive issues affecting the whole world, caused by so many things. As you say, I mean, caused by so many things. There's so many potential regulatory areas that can be engaged. I certainly have lots of questions, particularly on the human rights aspect for you, but I will open the floor to other people first. So maybe we'll start with questions in the room, and then we'll collect a couple in the room maybe, and then we'll go online after that. So anyone with a question in the room? Or a critique?
Okay. Thank you, Professor Sara, very much for this very detailed and provoking presentation. And I want to ask about the connection of the ICJ and ITLOS prescribed obligations with the individual rights of to the healthy environment. Because for me, it seems like these two advisory opinions are more targeted at states or governments. And as you mentioned, that the InterAmerican Court of Human Rights has prescribed the relevance of the individual dimension, but how we connect these two advisory opinions to individual rights, to the environment. Thank you very much.
I think this is I don't know if you want to take any other sort of questions.
Is there another question?
I think just start with that one.
Start with this one.
Okay. Yeah, I think it's a really good question, and it's not obvious. I will say that we're already seeing what the International Court of Justice had to say being referred to in climate litigation cases brought domestically, even if they are cases that involve individual rights. So in the Canadian context, we've seen reference to what the ICJ had to say. So it is a decision that's, an advisory opinion that's sort of based on the idea of state obligations. But at the same time, it asked and received and refers to the idea that states have human rights obligations, and human rights obligations are to individuals or groups, depending where you are. And therefore, that in and of itself becomes relevant or potentially relevant in a lot of different fora. So if you're in a state which has human rights obligations and somebody's bringing litigation and trying to invoke, in the Canadian context, charter rights, then how do you understand charter rights in light of ICJ? Is it irrelevant? We don't, in Canada, we have a Section 7 right to life. Must the right to life be interpreted in light of what the ICJ had to say about the right to a clean, healthy, and sustainable environment? I would argue that it should. That certainly that door would be open for people to make that argument that this it's not okay to say, to say right to life doesn't include or can't encompass this. So I think, so I'm not quite sure if that answered your question, but I think that at least is a piece of it. When it comes to the ocean, I think the work that's sort of taking place through the Human Rights Council and the resolution on the ocean and human rights, the report that was behind it, provides a lot of language for thinking about human rights, not just through an individual, but also collective dimensions, and also really draws attention to the role of ocean defenders, which is another piece. And there are big movements within the ocean community that talk about ocean rights, paralleling nature, and then talk about ocean defenders. So I think there's again sort of connections and linkages and possibilities. And that's as far as I've gotten.
Thanks.
Yeah.
Can I ask a follow-up question about how should we think about the realization of this kind of individual rights or in a collective way? For example, are there any mechanisms we can think of to achieve, argue that the state has not actually fulfilled its obligations from the human rights perspective?
Yeah. I think, climate litigation is a big field. Let's just put it that way, which could involve, bringing claims to the Human Rights Committee. So we've seen that with reference to coastal communities and climate adaptation and state obligations. So I think, to my mind, it's really a question of whatever the forum is, whether it's through a domestic court, whether you need to be exhausting domestic remedies, whether you're in a situation where you could bring a claim to a regional court, a regional mechanism. Just the key point is just to kind of brainstorm on it, and don't forget the ocean, right? Don't forget that there's this possibility that by invoking the ocean, by invoking the marine environment, it may bring in other legal obligations if your state is a party to UNCLOS, or if you can make the argument that some of these are customary international law. And there are a lot of states that are parties to UNCLOS, but not as many as are party to the Paris Agreement, for example. But it's there, and we need to figure out how to use it.
All right. Thanks very much. It seems for me like climate and litigation is a big area for me to explore, to go further into. But for sure, as a more law of the sea researcher, or I would be very interested to see how laws would be interpreted or applied or even carried out in other platforms or forums or courts.
I think it's new territory, and I'm not suggesting that sort of climate litigation is the only way to do things. And there are issues and questions in terms of what is climate litigation, what isn't it. Is there, I guess I would say, is there the possibility of ocean climate litigation, and what might that look like, or ocean climate biodiversity? How do we think about that, and would that open up other fora? But yeah.
Thanks for answering my question. Thank you very much.
Thank you. Are there any other questions in the room? My question actually that I was going to ask you there is quite closely connected to that. So maybe I'll ask my question now, and then I'll turn to the online people. So I was thinking, as you were talking here, about the concept of rights inflation, the idea that sometimes there's a risk perhaps that human rights are used too widely, tried to encompass too much, and therefore diluting the kind of core power that they're meant to have. So in the climate context, we've obviously got massive harm to human rights that emerges from climate change and other environmental issues. But then there is this issue of a lack of cause and effect. It's not easy to tie one company's or country's actions to a specific harm. So I'm wondering if you have any thoughts on where human rights are particularly useful here and where they perhaps should not be used so much.
Yeah. I want to go back in a sense to this the first slide where ITLOS is talking about the science. And I think the point would be that all humans are dependent on healthy planetary systems. The ocean is a very big part of a healthy planetary system. If we can't figure out how to use human rights to help to address the fact that the problems that climate change is causing to the ocean, if we can't use human rights to draw attention to that, to bring that into focus, then, you know, human rights aren't going to be that useful for us because our planetary system is going to be destroyed. So I think this is the point in a sense. And it's always important to think about rights and also responsibilities, right? And how that plays together. But the key point in a sense is that if we're going to talk about climate change and human rights, and lots of people are, and that's a big piece of, you know, the climate advisory opinions, then we need to bring the ocean into that conversation. And that's complicated and messy and not clear and doesn't make us happy. But the science is very concerning.
Thank you. Yeah, no, I can totally agree.
Tricky though.
Yeah, well,
I appreciate your question.
Yeah. I mean, it's a complicated question. Yeah, it's a new paradigm of problems in a way.
Right.
I will now just invite anyone online who would like to ask a question. We haven't got any written in the chat.
I think that's is that one notification?
Yeah, but not a question.
I'm happy to build on just in terms of the sources, if you want, just for one minute. So just to say that one of the things I've been doing through funding that we have through the Transforming Climate Action through the Ocean Initiative, I have a great postdoc, Cecilia Engler, and she and I have been writing a lot of things where we're sort of looking at how are people talking about the ocean and human rights, and how are the ocean scientists, for example, who talk about ocean rights, think that human rights are totally useless because they just focus on humans, and we have to stop focusing on humans, we need to focus on the ocean. And so they would be very hostile to human rights. But the Inter-American conception of human rights, to me, is the answer to that, because ocean rights are meaningless unless you have people who can actually go to court or go to some forum to raise the concerns. And so the Inter-American decision not only talks about this idea of rights of nature as part of a right to a healthy environment, but then has an extensive section on procedural rights. So substantive rights, procedural rights, and then also non-discrimination and vulnerability. And the work that you see happening through the Human Rights Council, as I've said, is really drawing attention to the role and the importance of ocean defenders. So you need ocean defenders exercising procedural rights in order to realize ocean rights. And that's, you know, there's human rights in there somewhere. Yeah.
I mean, absolutely. And I think the concept of rights of nature, ocean rights, is really interesting here as well, because I mean, obviously not new completely, but it's very much a topic that's an idea that's getting more and more popular and more institutionalized now. Mm-hmm. And I suppose it's this question of, in a way, it's almost a tactical question, right? Like what's the best particular tactic with the particular rules you have? Because I mean, you mentioned ocean rights, but there's another side of it as well, where if you're a particular expert on law of the sea, you could look at the law of the sea and say, well, look, we've got all these things you can make claims under. So maybe we don't need human rights. Maybe there are actually these regulatory requirements, if that's the right the law of the sea, but at the national level, it would be regulatory requirements, and maybe going down that route is more, in a way, more fair, because you don't need to find the one particular human rights claim that can win the case. You just regulate the emissions or whatever it is.
So I think the response I would have to that, so I teach environment, and one of the things we, talk about is, look, we've got these great laws, except there's almost no money going into compliance and enforcement. So you have almost no prosecutions. But there's a possibility of a private prosecution in some provinces, because in other provinces you bring it and the Crown will take it over and it will not happen. So I think the point in a sense is, look, the law of the sea says you're supposed to be doing all this stuff, but they're not. So how do you say you need to be doing all this stuff? Well, you could use, and I think one of the things that we anticipate might happen post the ITLOS advisory opinion is that you may have a state that is particularly vulnerable to climate harms going to ITLOS and bringing a contentious case against a state that is a high emitting state and saying all of those things. Look, you're not doing all of these things that you're supposed to be doing. So that can happen without a human rights lens, and that's great, and we hope it happens, and that would be really important. But the human rights lens, and particularly if we're thinking of sort of the procedural, when I think of sort of a human rights and environment lens, it really focuses in on the importance of procedural rights, and who has standing to go to court to do what. That I think is nevertheless still a really important avenue that needs to be explored.
Yeah, absolutely.
Yeah.
Absolutely agree. Yeah. Anyone else in the room have a question on anything on Andy?
Yeah, I'll just thank you very much. It's really interesting. I just had a comment on the kind of relationship also to seabed mining here, because there's obvious relationship, but it's kind of, again, it's difficult to draw the exact human rights impact out of that. I think it's something that human rights is kind of struggling with a little bit, is that collective dimension that you mentioned. So I'm not sure if there's a question there, but
yeah, but I think it's really interesting, right? Because I mean, the UN Convention on the Law of the Sea does create this whole regime for deep seabed mining, and we have ISA, and there's no reference to human rights as such in it. But you have people saying, look, as you're putting together an impact assessment regime, it's not okay anymore just to be focused on environmental biophysical effects. You have to figure out how are you going to bring in participation rights and who are the people who should be, in different contexts able to be part of that conversation. So those conversations are happening. And in the BBNJ, there is explicit reference to Indigenous rights and local community rights, not to individual human rights. There is some attention to gender in certain pieces. But there is so far a tendency for regimes that deal with ocean or deal with biodiversity or deal with other things to kind of take the humans out. And climate has been the same thing. And gradually there's been okay, we need to have Indigenous people and local communities in. Okay, maybe there's a gender dimension that should be in. Okay, youth, children, future generations, we get it, they should be in. But you don't yet have that sort of fulsome human rights conversation happening. And I think it's starting. Yeah. And it includes in the deep seabed mining context. So, yeah, absolutely.
Any other questions? I had a tiny follow-up question based on Andy's question there as well, Sarah. So I suppose it got me thinking. I mean, of this sort of victim-violator relationship. It got me thinking again. I mean, deep sea mining is so destructive, and so far as I know, exactly what damage it's causing is not really even known, because the ecosystem is not very well known down there. But again, so I mean, maybe that should be prohibited prima facie. But there's this lack of the clear victim violator link, right? And so, I mean, it's not really a question again, but it's just a kind of a comment, I suppose, on the complexity of it, right? It's like there's so many different loops in the chain, and whether it was like deep sea mining or particular uses of energy that are maybe not necessary and very extreme. Can we say from these sorts of opinions or anything like that, I suppose, to turn into a question, can we say that there is sort of some red lines we can draw here Do you think that's an emerging trend, possibly?
The red lines are difficult. I think there are trends in that way, but there's also a lot of contestation. So one of them would be over marine geoengineering or marine carbon dioxide, Atlantic Convention, Atlantic Protocol, different kinds, much contestation, including must we start to develop these technologies as climate solutions because of the mess that's being made? And would it be a human rights violation not to be actually taking the steps to find these solutions? Or, is just the process of doing these in themselves, because the risks are potentially so high to the marine environment, to humans who are dependent on it, that we should or shouldn't do it. But I think this is where, for me, the framework of a right to a clean, healthy, and sustainable environment is super important. You can look at it as having substantive dimensions. So if you look at the work that special rapporteurs have done and others, you can talk about a safe climate, clean air, clean water, healthy biodiversity of ecosystems, non-toxic places, and safe and sustainable food. Sort of the 6 kind of substantive components. But the procedural components are equally important. And I think, and that starts with information. The rights to information, to access information. This includes embedded within it ideas of right to science, freedom of expression, education, and all of that to enable participation, to enable better decision making. And then, of course, there's the sort of non-discrimination aspects. But I think the point would be that whatever these decisions are, if you take a right to a healthy environment frame, you can bring in the procedural dimensions. So it's not just some guys off over there for making these decisions without anybody accessing information, able to contribute. And that includes, in environmental matters, huge questions about who's doing the science, who's funding the science. Is the science being made public? Who can access the science? Is there, sort of whose science is another kind of piece of it, right? There are all these questions that kind of come into this. And I think that's why whenever we're dealing with marine environmental or environmental issues, generally that procedural dimension is so critically important. Needs to be sort of understood through human rights. Or I think a human rights lens leads us to that.
Yeah.
Yeah.
Yeah, thank you. Going off from what David raised, seabed mining.
Yeah.
Sometimes it seems to be paradoxical to me that a lot of seabed mining is done for rare earth minerals that we use to produce electric vehicles, which are supposed to be good for the environment.
Yeah.
But seabed mining itself could be intrinsically harmful for marine environment or climate. So how do we reconcile this conflicting stuff?
So I will say I had a PhD candidate who was a former sustainable finance guy who did his on seabed mining, and he dug up stuff that basically said we actually don't need any of this. The claim that doing this is to deal with the need for transition stuff is actually just bogus. I don't know if his sources were right, but that was one of the points that he made was, okay, so we can, this isn't actually true, but even if it was, and then he sort of goes on to propose how to think about this regime. But one of the key things, again, in the seabed mining context, and I think this sort of links over to just thinking about the climate and impacts on the marine environment, is there's so much that is not known about the ocean and the depths where seabed mining is going to take place. So when decisions are made to do things with such uncertainty and such potential risks, it becomes either it is a no-go, we're just not going to do this, moratorium, and there's certainly a lot of push for that, or it's got to be the procedures must be inclusive, transparent, slow, scientific, sharing. It has to be that way. Otherwise, it's not excusable.
Grounded on precautionary.
Absolutely, yeah. And you see ITLOS saying the precautionary principle is not referred to in the UN Convention on the Law of the Sea. Nevertheless, due diligence must be understood through a precautionary lens. And pollution of the marine environment in and of itself is precaution, the need to address that is in and of itself precautionary. So the precautionary approach and bringing that into the, I think one of the things that's interesting about this resolution on human rights in ocean and the reports that go into that is the bringing together of human rights with an ecosystem approach, human rights and the precautionary approach. These are really interesting and important conversations, I think, that can hopefully help sort of lead to better decision making and more holistic thinking.
Excellent, thank you very much. I completely agree with that. So bridging those kind of gaps between human rights and other areas. I think that's a good point to leave it there. We're just about out of time. So thank you very much, everyone, for attending. Thank you very much, Sarah, for those insights.